And we're back. Thank you for joining us on Let's Talk About This. Our next presenter, panelist today is Rihanna Check, who would like to talk about.
I wanted to talk about kind of how the Supreme Court has been functioning over the past, say, 10 years and how some of the laws and the focus have been heavily dictated by party politics. 10 years ago, when it was a more even, even 5 years ago, when it was more of a split, and you could have a swing vote that could decide one way or another. We had almost a more fair interpretation of the Constitution, but seeing it as we've stretched from a conservative to a liberal, or more conservative court versus the liberal court, or even like the split court, the focus of some of the laws have been very targeted towards an agenda rather than actually interpreting the constitutionality of a law. You can see it in the in the decisions being written about the things that are showing up in front of the court. And I think that, if we're going to be talking about people who can be the checks and balances of both the president and the Senate and Congress, they should be held to higher standards of what they can and can't do in regard to the idea of how they determine these laws. So like the prime example I had was being able to, abstain against something that is a direct personal conflict.
So you're suggesting the justices of the Supreme Court should be more open to recusal from cases, especially if they are in any way even remotely entangled in the arguments being presented.
I don't even mean remotely. I mean more of like a person. Like if my mom were a judge and they were the only judge of, say, Erie County, where I grew up, and I had to go in front of my mom, do you think my mom would be biased about potentially sentencing me? I mean, depending on my relationship, yes. But if there's something of a personal nature and or a financial nature that could potentially sway a judge one way or another, there should be harsher rules to penalize them from not recusing themselves.
Kind of like Clarence Thomas and the Harlan Crow scandal that has blown up over the past year or two.
I mean, Clarence Thomas is a lot. There's a lot he should have probably recused himself from.
Glenn, what are your thoughts on this?
Well, I totally agree with the corruptive factor here, and Clarence Thomas is that shining example of corruption in modern American politics. And the Supreme Court, for someone who does swing more conservative here, I like a lot of the Supreme Court interpretations as of late, only in protection of states' rights. We all know why they did it, the actual motivation behind it. For some of these decisions, Roe v. Wade, I'll put right out there. Yeah, they were definitely politically biased, but I do believe that it works well and more effectively for states' rights. But for corruption, if you're entangled, this goes into the whole being lobbying and bribing, how much money is actually passing through for some of these decisions through forms such as ALECs, which still swings, though they don't write for the Supreme Court. They're the ones that are funding these federal judges to be nominated to the highest court in the nation anyways. And Clarence Thomas should have recused himself on probably more than a few things, especially when he's taking donor money in order to make these decisions. It just talks about legal corruption in the United States. I think that's just a blanket thing where we should end all lobbying, period.
I mean, and I would like to make the point about, I understand where you come from, being, a libertarian and the states' rights, but these are just like, and these are what without saying the name of the court case that you might not understand, this is what most people have come to know some of these court cases as. And this is just from this 2024 cycle. Immunity of former presidents, rights of platforms, January 6th obstruction charges, power of federal agencies, restrictions on homeless. I'm going to skip this one because it was dismissed, but I'll come back to it. The opioids settlement, cross-state air pollution, administrative courts, disinformation on social media, gun rights, bump stocks for guns, abortion pills, NRA and the First Amendment, racial gerrymandering, agency funding, and Trump's ballot eligibility.
Okay, well, on my end of it, just for Supreme Court, I'll start with, well, that's January 6th. What was the one before that?
Rights to social media platforms.
Besides that, of course, you should always have complete and independent control. There should be no restriction on the information you get. But from a conservative point, I do believe that they do have more traditionally a conservative interpretation of the Constitution. Is it highly weighted? And like I say, with the motivations, I believe that actually make them lead to those decisions. Are they biased? Are they? Yeah, I would totally agree with that.
I do like that you brought that one up. The social media platforms, First Amendment rights. It was actually a 9-0 ruling to return it to the lower court's decision, where the Supreme Court left it to because it was the law that said, or where Florida and Texas as a state tried to curb the power of social media companies to moderate content.
And I think for free speech platforms, since Facebook and a lot of social media, they're actually platforms. But I can't tell Facebook what I'm going to put on Facebook. I do believe that that is private entity, and if they want to moderate and have fact checkers, unfortunately, that's up not even to the state. That's up more to the free market. If you don't like it, don't use it.
And that's kind of where I'm.
But disinformation as well, being able to scan and openly. There's a balance here, but no, I openly believe that the company has more right than the state does in what they can moderate and what they can't.
Okay, so then you agree with the Supreme Court on that one?
Yeah,
So-
yeah.
Okay, well then I would compare then Facebook to standing in the town square and making a speech. The people have the people of that local community have the right to decide what is said and what isn't said by whom and for how long. For example, there are rules and permits that you have to follow in order to be able to speak in the town square. Okay, you can't.
I don't agree with those.
and I agree. I think there's quite a few limitations on free speech. Some of them are practical, others are nonsensical. But with that said, I think it's important for us to remember that again, Facebook is more like a theater then. If the theater doesn't want your show to go on, they don't have to put your show on.
I do want to jump back to that because you say that you don't believe that the laws against like going out into the square and speaking out, you need permits, or you don't believe in that, right?
Not in time, utilization fees. Okay, I can see that, but to actually restrict my free speech based on a state permit.
So the restrictions on homelessness, the one that the court ruled in a 6-3 favor, was actually the Supreme Court upholding ordinances in Oregon aimed at preventing homeless people from sleeping and camping outside.
From squatting, and I don't agree. I don't believe that. It's your individual right to egress as long as you're not preventing egress for someone else, threatening their bodily, safety, or taking their stuff. Hey, they're a taxpayer like the rest of us. They're a citizen like the rest of us. Yes, I want to see them sleeping on the sidewalk. That's a horrible thing to watch and witness. But the government should not have the right in order to come and remove them if they're not.
The court did uphold that.
Oh, and I understand that. That's still a more what would be considered. Actually, I'm surprised, but more liberal ruling because they favored the state over the individual's rights.
So Glenn, if I'm understanding you correctly, you side more with Justice Sotomayor, who opposed the majority opinion and believed that people who are homeless, instead of being kicked out of wherever it is that they're sleeping on the street, should be helped or encouraged or empowered.
Let private charity come in, let the churches come in, let private charities come in, nonprofits come in order to help.
Let social workers take the lead.
Yeah, I'd much rather see that. So yes, I would be more in a dissenting opinion on that. Because they're not hurting anybody. As long as you're not hurting anybody or taking their stuff, you're not a nuisance, you're not blocking egress, which is a thing. Then
and that's the thing, like you've seen like the park you've heard the thing about New York park benches where they tried to put the
Yeah.
weld in the metal dividers so the homeless
Yes,
didn't
I
sleep
did.
on them.
God, yes. And I just, especially for waste of tax money, and I'll go back to, taxpayer rights on this as well, to address a problem that hurts no one except the city budget.
Adam, what are your thoughts on this?
Yeah.
About the the homelessness and the
And the
tomfoolery.
Supreme Court ruling, yes.
I don't stand for it one bit, Listen, everyone has a hard time, and most of the time, and what they found is that it's mental illness. So treat the core cause, and boom. I'm not saying that we should offer them free housing, but we should offer them at least something to help to get them off their feet. Give them a little bit of humanity, because we're not primates, we're human beings. We care, for crying out loud.
And
why not help someone and just help fix a problem,
I guess my issue with this is that by the Supreme Court upholding this ruling, it now becomes precedence that every single court from that point down can use as a justification to charge, say, a homeless person with disrupting the peace, even because Oregon, the Supreme Court determined that Oregon was allowed to set this ordinance aimed at preventing homeless people from camping.
So just to clarify, Rihanna, that particular ruling was not tailored narrowly so that it only applied to those rules in Oregon or in that particular community. It's a nationwide precedent that other jurisdictions must
Anything that the Supreme Court upholds as law is an interpretation of the Constitution and then can be used as precedents to be upheld elsewhere.
Everywhere in the United States.
So say if in Erie, Pennsylvania, we decided we wanted to put an ordinance saying homeless people weren't allowed to sleep on the sidewalks.
Okay.
And somebody tried to fight against that and take that to either the local or federal court, any sort of prosecutor can now claim it was the city of Grants Pass versus Johnson in their justification for saying that the city of Erie can pass that law.
Okay, and here's why I'm asking about the narrowly tailored ruling. In the Masterpiece Cake Shop ruling back in 2016, 2017, I think it was.
Yes.
A while ago. They ruled that the owner of the Masterpiece Cake Shop out in Colorado had his rights violated and that he should be allowed to discriminate against LGBTQ customers. But the ruling was very clear that it only applied to his individual case. It wasn't set as precedent. And in fact, that case was returned back to the Colorado Supreme Court for further rulings.
So, and that's what I was talking about when we were talking about the social media platforms. They kicked it back to the lower court and said, hey, we stand with the court, or the lower court saying that Florida and Texas were out of line.
Mm-hmm.
That didn't set national precedence. This did, because they upheld it, saying that the highest court of the land believes that this should be the precedent set.
Incredible times we live in. And that brings us to our next brief break. And when we come back, we're going to hear from Adam, who is going to talk to us today about his particular topic. Come on back in about 2 minutes, and there'll be more. Let's talk about this.